All right, let's go back to 2010. A 15-year-old kid is at home in his bedroom doing whatever it is that 15-year-olds do. All of a sudden, the little green dot next to the webcam on his school-issued laptop turns on. Oh. Cue the dramatic music.
Oh.
What happens when a school district gets caught remotely turning on students' webcams?
Well, I guess somebody probably thinks that their privacy was violated.
Nothing good would probably be the right answer, yeah.
Yeah, exactly. So you might have heard of this one, everybody. The name of this case is Robbins versus Lower Merion School District, but it is better known as WebcamGate. Yeah, you might have seen the Amazon docuseries called Spy High, and if you did, you might have some feelings about this one. This case has everything. A wealthy suburban school district, secret surveillance, candy, allegations of drug dealing, whistleblowers, six-figure settlements, and maybe some lawyers with some less than altruistic goals.
No.
You know, when I said that, this case has everything. I felt like Stefan from SNL. You know, who is it? Is it Bill Hader?
Yeah.
This case has everything. Anyway, welcome to Chalk and Gavel, everybody, where we explore how the law shapes education one case at a time. I'm Jamie Cudlitz, a former middle school math teacher and principal.
And I'm Chris Thomas. I've been a high school English teacher and a school attorney. Now we're both professors of educational leadership, telling the fascinating stories, connecting the courtroom to the classroom.
Is for educational purposes only. While Chris and Jamie always try to provide accurate information, the law is like what I'm willing to eat. It's always changing. This podcast is not legal advice and does not create an attorney-client relationship, but they promised me it would be a lot of fun. For you. Can I get my candy now?
So the kids are alright.
All right, welcome back, everybody. Before we dive into WebcamGate, Chris, what's our bell ringer for today?
Yeah, so speaking of technology and potential harms from technology that we don't understand, remember the social media lawsuits we discussed a few episodes ago?
Yes, I do. I remember it very well because I had such trouble editing that episode because the whole, my audio got all messed up. And yes, so I remember that one well. That episode scarred me.
Well, I hope our audience remembers it too, that we actually published it because we're recording this before that technically comes out.
Yeah.
Anyway, a little behind the scenes for you. But one of the other lawsuits that's being really closely watched just settled. So one of the social media lawsuits has been settled. This is, I think it's Breathitt County School District in Kentucky. They reached a $27 million settlement with Meta, TikTok, Snap, and YouTube. And like all of the lawsuits that we've talked about with these school districts suing social media companies, the district alleged that these companies designed their platforms in ways that encouraged compulsive use among young people, and that this contributed to student mental health challenges, anxiety, depression, self-harm, eating disorders, all of that. And because of that, school districts had to deal with those additional burdens, increase counseling, behavioral supports, mental health services. So this probably all sounds very familiar. It's the kind of the same brand of lawsuits that we've been talking about with schools suing social media companies.
Yeah.
But, this is a big one because this is the first one. It was expected to go to trial, it was expected to go to court. And instead of proceeding to trial, they settled the case.
That's crazy.
So, yeah. Meta agreed to pay $9 million. TikTok and Snapchat each agreed to pay $8 million. And YouTube agreed to pay $2 million.
Wow.
Yeah. So, and Google, who, owns YouTube, they agreed to provide training to the district on, some of their Google suite of products as well. So like big news here because like, a $27 million settlement isn't a massive deal for these companies, bottom lines, but like, but it's still like, that's a big chunk of change. And it doesn't necessarily show that these companies are like, they did not admit to wrongdoing.
I was going to ask that. Yeah.
No. So like it could have been a business decision where it's like, hey, the $27 million to settle this case is
make it go away. Yeah.
Make it go away. Like that's just the cost of doing business because litigating this thing and like, the risk of an adverse outcome, so it's, I don't want to read too much into it, but that is settling this case is a big deal.
Yeah.
$27 million seems like a good chunk of change too.
Well, yeah, it does seem like a big deal because the case that we talked about a few episodes ago, like there's a lot of school districts involved in this. It's national. It's a huge thing. And if this one was settled for that much money, even though $27 million for these companies is not a lot, when you multiply that by all the other potential,
there's
current and potential.
Yeah, there's about 1,200 outstanding cases.
Well, then it becomes significant, and this thing seems to be...
Right, but this one I think was separate from the consolidated cases that we talked about. And so, like, but I see what you're saying. Like, if you aggregate that $27 million times 1,000 school districts, like...
Well, I get that it's not part of that other lawsuit, but it is the same topic.
Right, it's the same claims, right?
Yeah. And so if this is how those companies are saying, you know what, we don't want to fight this, and, they're probably deciding that they're not going to want to fight this because to fight it, they either could lose or could lose more than 27 million.
Right.
But I mean, they're making a calculation here.
For sure. Interestingly, I'm pretty sure this settlement, though, not only did they not admit to wrongdoing, which is pretty typical in any kind of settlement like this, the social media companies didn't agree to, like, it didn't include anything about, like, them changing what they're doing. So, like, this was very much just here's $27 million, this is over, and, it doesn't bind us to change anything.
That's big, though. I think this is big. And obviously, it's probably going to come up in the existing lawsuit.
Oh, I'm sure.
Lawsuits, right?
Yeah.
Wow. Cool.
Yeah. So, speaking of the harms of new and untested technologies, Jamie, what's our case?
Okay. We will get into our case, but I want to say one thing really quickly first. I want to say huge thank you to our research assistant, Andrea Morris. She did all the work in researching and preparing this particular episode. So we couldn't have done it without you, Andrea. Thank you so much.
Yes. Thank you.
Yeah. Okay. I'm glad we're covering this case because it's a good one. All right.
Yeah.
So this case comes from the Lower Merion School District in Pennsylvania, just outside of Philadelphia. All right. So here's our context for you all. It's one of the wealthiest public school districts in the entire state of Pennsylvania. Okay. And here's how wealthy that district is. We'll let you know.
Okay.
The median home value in Merion School District is just over $800,000. Okay.
Ooh.
That's the middle.
Some nice houses.
Some expensive, nice houses. The district also spends over $38,000 per student.
Wow.
Okay. So just to give you all a little bit of context, folks, the state average in Pennsylvania is about $22,000 per student, and the national average is closer to about $17,000 per student.
Wow.
So this district is spending more than twice as much as the national average.
Right. And almost at least more than half again as much as the average in Pennsylvania.
Yeah.
Okay. So
I mean, and so the last bit of context here about how wealthy the school district is that there was a joke going around town that it should be called Lawyer Merion instead of Lower Merion
I
because
like
of
that a lot.
Yeah, because of how many attorneys and other highly educated professionals live there.
Yeah, if there's one place you want to bring a lawsuit, it's in a place that is jokingly referred to as Lawyer Merion. All right, so like elite suburb, they take their schools very seriously.
Yes,
Okay.
yes. And side note, thanks, Andrea. For the record, notable alumni, Kobe Bryant.
Whoa.
Yeah.
Okay.
One of the
That's
greatest
pretty cool.
basketball players in the history of the game.
Yeah.
Yeah.
Given your sports ball knowledge, I'm surprised.
No, Andrea wrote that. It is
everyone
not,
knows Kobe. Right.
It is not my opinion that he is one of the greatest basketball players in the history of the game, not because I don't believe that, but because I don't follow professional basketball. I know who he is,
Of course.
but I don't know enough about other players to compare him.
All right, we'll have the conversation about
Yeah.
the NBA GOAT later.
Okay. I will not be involved in that conversation because I've got no skin in the game, as they say. Okay, so it doesn't matter because Kobe has nothing to do with this case.
I was gonna say that'd be an interesting a wrinkle.
Yeah. Oh, twist. Okay.
He was probably well out of school by 2010.
Yes, I would think so.
Yeah.
Okay, so here we go. It's the 2008-2009 school year, all right? And the district decides to pilot a one-to-one laptop initiative at Harrington High School. That's one of two district high schools in Lower Merion, in Lawyer Merion. Keep in mind, this is 2008. This whole one-to-one thing,
Right.
pretty new, right?
Yeah, that's what I was thinking.
Yeah. So most districts in the country, they're nowhere near providing one-to-one
No,
laptop
most didn't
programs.
do anything like that until COVID, or many
yeah.
didn't.
Many
that was a
didn't,
big
right.
turning point.
Yeah, yeah. And these weren't just any laptops.
Oh yeah,
These were MacBooks.
the Cadillac of laptops.
Oh, the Cadillac.
I don't know if anyone's actually called them that, but
Is
like
that
they're very nice
is that a
laptops.
thing? Yeah,
and
they're good laptops.
They're, compared to some of the other, like, the Google Chromebook does what you need it to do, but
Yeah,
it's
yeah,
also
yeah.
like a tenth of the cost of a MacBook.
Yes,
Sometimes.
exactly.
So like,
yeah, like these
this is-
MacBooks, 2008, they're not $200 machines.
No,
they're
they're like
probably
$2,000.
$1,000 or $2,000,
Yeah.
right? So everybody's excited. Kids are excited. Parents are excited. The future is now.
yeah,
Or it was 2008 in Lower Merion.
the future was then.
It was then. When will then be now? Soon. Hey,
Spaceballs. Yeah, there we go.
Okay. So Lower Merion, very proud of this initiative. The superintendent's welcome message on the district's website at the time offered this glowing tribute to the initiative, saying that
I
it
can
provided,
imagine, right?
Yeah, it said that it provided, quote, an authentic mobile 21st century learning environment, unquote.
It's a lot of words to say
Yeah.
we're giving you a laptop.
Yeah. And don't get me started on the whole 21st century learning thing.
Yeah.
you know.
It's a different soapbox.
Yeah. Okay. Moving on. They also, they like to brag. Okay.
I can imagine.
So the message also said, quote, while other districts are exploring ways to make these kinds of incentives possible, our programs are already in place. I don't know if it said it with that tone.
I think they wrote it in that tone. It's like the alternating cap.
Yeah, right.
Yeah.
It also said, it is no accident that we arrived ahead of the curve. In Lower Merion, our responsibility is to lead.
Okay. And I'm imagining that last quote aged perfectly.
Yes, as we will describe in the forthcoming description of the lawsuit.
Right.
Okay, so behind the scenes, here's what's happening. The district IT department decided to install a piece of software on every machine.
Okay.
Very
that
common.
they were giving out to students.
Yes, that they were giving out to students. Very common. This software was called LANREV, LANREV.
Okay.
And it included a feature that was called TheftTrack, which, interestingly, has since been discontinued.
I wonder why.
Yeah, So the idea behind TheftTrack is that if a laptop goes missing, IT staff can remotely activate the software that they installed on the machine, and it'll take a photograph through the built-in webcam of whatever is in front of it, or take a screenshot of whatever is on the screen on the laptop. And it will also capture the IP address. Okay?
So anti-theft, we can remotely activate this to like basically see who's using it, I guess, or where it is?
Where it is.
Yeah. Okay.
Yeah. So those pictures, that information gets sent back to the district servers and can be provided to the police if needed. District locates missing or stolen laptop. Everybody wins.
Well, maybe.
Except for whoever stole the laptop.
Or whoever you're taking pictures of.
Yes. I mean, they might eventually win.
Yeah. So like I get where they're coming from. Because it's an anti-theft system. I don't necessarily think it's an ideal anti-theft system because it doesn't like you're just right, but like laptops are expensive.
We're giving somebody a $2,000 piece of equipment, right?
We're giving kids a $2,000 piece of equipment, right?
Right.
Right. So you want to be able to track it back. Like just it doesn't feel like the best way to do it, right? Like there's got to be a better way to do it. Because honestly, what this feels like is, and this is kind of one of my takes on this entire situation as we talk about the whole thing, is like, it just feels like the district and the IT people got a shiny new toy and they just wanted to play with it and all of the cool things it could do. And one of the shiny new toys was like, oh, I can remotely turn on their webcams.
That's cool.
That's cool. Yeah. So like, I think like, and that's to me, one of the big takeaways here is like, just because this software is so cool and it can do these things, like maybe take a second to think through what that actually means.
Which I don't really think they did, or at least they didn't particularly care to do. And let's talk about why.
Right, yeah. So
here's the first big issue with all of this. Not the first issue, because the first issue is the idea of tracking. But the big part comes in when they decided, you know what? We're just not going to tell anybody about this.
Right. Yeah. We're not going to share that we have this capability.
Yeah. Right. Yeah. There's no families were told. There was no consent form. There was no mention of the tracking software in acceptable use policies. There was no heads up whatsoever that this capability existed. Not a word, nothing. None of the written documentation that accompanied these laptops disclosed the district's ability to remotely activate the embedded webcam at any time to capture images of whatever was in front of the camera. Nothing.
And on the screen, right? Yeah. So
and on the screen.
And this is another example of like, this is such a new technology that like the policies and procedures hasn't caught up yet.
Yes.
I don't want that to slow down innovation, but it's important to do these things responsibly.
Exactly. Now here's another even crazier thing. You ready?
I was born ready.
Someone inside the district IT department noticed what this software could do and thought of the implications.
Oh, good. So we've got a whistleblower. Now, you might think, Chris, that this whistleblower was an administrator or some high-level IT professional who, or some mid-level or some low-level IT professional who might not have been involved in any of the decision-making process, but saw this and went, wait a second. But no, you would be mistaken. It was not an employee. Okay.
It was a high school kid who was working as a tech intern in the IT department.
All right. So some student sees what this can do and just is like, wait a second. Know what this means?
Yeah. So in August 2008, right before the program launched at Harrington High School, this student sent an email to the director of instructional support with the subject line, "1-to-1 concern important." Okay.
Descriptive. Good.
Yes. He wrote that he had recently learned about the district's purchase of the LandRev software and described his discovery of its ability to remotely manage computers outside the network as, quote, something startling. Okay. He wrote, quote, I would not find this a problem if students were informed that this was possible for privacy's sake. However, what was appalling was that not only did the district not inform parents and students of this fact, he went on to say that he could see not informing parents and students of this fact causing a huge uproar. Well, who is this kid? Let's get him an internship on the show. Right. He's not a kid anymore.
No, not anymore. But yeah, very. He's predicting the future here because uproar, I think, is a good word for what is about to happen.
Well, not only is he recognizing some potential legal implications when he mentions privacy concerns, okay, right, but he's also recognizing the sort of public relations potential fallout with a community in an uproar.
Right, because there's no communication here.
Exactly.
Right, and that's a massive issue, is that lack of transparency.
Right, totally. Okay, so it keeps
getting better.
The IT director responded 7 minutes later.
Oh, no.
What does that say to you, Chris?
That is 100% a brush off.
Yeah, like you don't have time to do a lot of good research in 7 minutes.
Thank you for your concern. I do not share it.
Yes.
Goodbye.
Would you like to know how the director wrote, thank you for your concern, I don't share it?
Yeah. Goodbye. In more words, I'm guessing.
Yes. She wrote, quote, I am not sure that what you have found is correct. What I do know for absolute certainty is that there is absolutely no way that district tech people are going to monitor students at home. There is no plan, no staff, no desire, and I believe no technical way to do that, unquote. Okay? So obviously she didn't do her research because there was a technical way to do that.
And that, I think, is really telling too, because with technology, there's always going to be people who know it really, really well. And then there's going to be other people who don't know it as well.
Yeah.
And if the IT people are the ones implementing this policy, but they're not necessarily the decision makers don't know all the capabilities. It might just be not an ignorance issue, but
well, they just weren't at the level to know that specificity. But if you're at that level not to know that specificity, you should probably ask somebody who does before you make a claim.
Be so dismissive, yeah.
Well, she gets even more dismissive because she ends the email with the quote, this is something this really rubbed me the wrong way when I saw this. She ended the email to the student IT intern.
Yeah.
With, I suggest you take a breath and relax.
Oh, no. That's the calm down.
That's such patronizing.
Right.
Condescending anyway.
Mm-hmm. Well, and, we're looking at this from hindsight, but the student whistleblower was proven correct.
Right. Okay, so the director of instructional support then forwards the email chain to the district network manager. He drafts a longer response, reassuring the student that TheftTrack was only used when a laptop was reported lost or stolen, that it could only be activated by 2 people in the department, and that it captured only IP information and, quote, occasional screen and camera shots, unquote, to assist police. He closed by telling the student intern, being a student intern with us means that you are privy to some things that others rarely get to see and some things that might even work against us, unquote.
Ooh, so it's a mighty fine job you have there. It's a shame if something were to happen to it. That's a keep your mouth shut kind of thing.
Yeah, or you'll be swimming with the fishes, see?
Right. Or we're going to turn your webcam on.
Yeah. That sounds a little kind of almost threatening.
Yeah, right. I do appreciate that this district network manager actually seems to know how the technology works. That's good.
Yeah, and he seems to indicate there's a plan for when and how to use it.
procedures, yeah. Like,
Yeah.
though my understanding is those were never formalized necessarily. And also, like, this idea that only 2 people can do it, I guess that's important. Like, but who's what's the
2?
oversight here?
Yeah.
And also, who's the 2, right?
Yeah, and who makes the decision? Is it the 2 that make the decision or somebody else?
Right.
Anyway, there's
There's
a lot.
A ton of open questions that probably should have been answered before they implemented this technology.
Yes, but they didn't, and there was a lawsuit. And anyway, so the student writes back thanking the director of instructional support and promising that he would not spread information about the, quote, LoJack-like methods that the district employs. I like this kid.
Good. Yeah, right?
So just, I don't know if LoJack is still even a thing, but back then, you would put this LoJack, it was like a transponder or something in cars to track stolen cars. And it was a company, I think, called LoJack, right?
If you say so.
Yeah. So anyway, the student referred to this software and methods as LoJack-like. The district manager replied with this quote: "The Big Brother concern is a valid one, but I assure you that we in no way, shape, or form employ any Big Brother tactics, especially with computers off the network."
Ixbay on the Ig Brother Bay. Like,
Oh, Big Latin now.
maybe don't mention the phrase Big Brother.
That is some good advice.
Yeah.
Yeah.
Like, hey, by the way, I recognize that this could be incredibly intrusive straight surveillance of individuals in their private homes, but don't worry about it.
Yeah. Yeah. Oh my God. So 2008, all that happens. Kid was brushed off. Laptops go home.
Right.
That's the story. That's the setup.
Right. Yeah.
So
that's all prologue, right?
yeah. So before we get any further, we got to introduce the main character here. Blake Robbins was a sophomore at Harrington High School, and by all accounts, maybe not, the most prim and proper, straight-laced kid. Okay,
Yeah.
He had some history in the principal's office. He was no stranger to minor disciplinary matters, tardies, things like that. All right.
Sure.
Also a very popular kid, big personality, life of the party type, right?
Okay.
So the documentary program on Amazon that we mentioned, that program describes his family as a little rougher around the edges compared to the typical Lower Merion family.
Interesting.
Defined by money and accomplishments and all
Right.
that stuff, right?
So there might be like an old money, new money kind of thing here.
Possibly.
Maybe something like that, or a different side of the tracks sort of situation. Yeah. Okay.
Yeah, possibly. No, on November 11th, 2009, Blake is called into the assistant principal's office where the AP, Lindy Matsko, confronts him about what she describes as improper behavior.
Okay. So this is our inciting incident, right?
Yes, this is the inciting incident. She is concerned that he is using and or selling drugs.
Dun, dun, dun.
How did she get this evidence? Did she hear about something transpiring in the school bathroom or in the hallways or in the parking lot out there?
Uh-huh. Did she search his backpack?
No. Her evidence was she said she had photos of Blake holding drugs.
Huh.
So she shows...
That's just sloppy.
Yeah, she shows Blake a photo. It shows Blake holding a small item up to his webcam.
Like this?
Yeah, like that. And it kind of, the AP thought it looked like a pill. Okay?
Yeah.
He was
like a small, yeah.
Yeah, he was video chatting with a friend. He holds this up. The AP thought it looked like a pill. And given Blake's history, the fact that he had at some point been accused of selling marijuana, I guess, she assumed that what he was showing was drugs.
Right.
She told him that the district had photographs of him and would be turning them over to the authorities. Okay? Blake, for his part, notices that the background of the photo is his bedroom.
Right.
Okay? And it was taken in the evening. All right?
Yeah. Well, and he's also video chatting with a friend, right? So
Yeah.
like there's another student. So if it's a screen capture, there's another student there too,
He wasn't
right?
video chatting at night with the AP showing.
Right. Okay, so obviously, like, you know, Blake's first reaction has to be like, where in the world did you get this picture of me in my home, in my bedroom, talking to my friends? Like, that.
Yeah, because after all, they were not notified that the district had the capability of doing this. So
Right,
he's
yeah.
probably like, how did this happen?
Right. Oh my gosh. And I think, like, to also just take a step back, like, why, if you're the assistant principal, how do you, I guess I'm so confused about her decision to use this picture as evidence to confront him. Because, like,
Yeah.
you have to understand, like, this is a picture of a kid in their bedroom, that you obtained through some, like, you know, I don't even know at that point if she knew how they had obtained the picture. So, like, it's just this like, this one little thing, the decision to use this picture to accuse him of drug use or whatever, like, snowballs into this massive thing. But, like, just that decision of, like, if you're collecting this evidence, how did it get to her hands to use to accuse him of this? So, like,
Yeah.
if it's the IT people collecting it to find stolen laptops, how did it get to her?
Yeah.
So, like,
Yeah.
there's so many questions that I have about what was going on behind the scenes.
I don't believe that any of these folks were chalk and gavel listeners.
Not in 2008, no.
No, you were still in grade school, right? Or something like that.
No, I was probably a junior in college,
Okay. But
you know.
but we hadn't come up with this amazing plan yet.
No, I was still probably a mechanical engineering major at that point.
Oh. We'll have to talk about that later. Okay. So Blake, who understandably finds it odd that his principal had pictures of him in his bedroom.
Odd is probably doing a lot of work there.
He goes home and tells his parents.
Yeah.
Mom talks to Miss Matsko, was unable to get answers, so she then calls his school counselor. Okay. The counselor tells her that she can't say where the photos came from, but at least this is according to Mom. Mom says that the counselor advised her to get a lawyer involved.
Right.
That I don't know.
Somebody at the district is like,
I mean, obviously, the counselor finds this problematic. I don't know if it's advisable for a counselor to counsel parents on getting legal
lawyers
counsel
to sue their employer.
to sue their employer. But again, that's according to Mom.
Right.
So Mom calls her lawyer, air quotes, for all you audio listeners out there.
So you've got a running relationship. This is not
with an
your
attorney.
not your first rodeo.
No. But they also live in Lawyer Merion.
Right.
Right.
So, you know,
So they
everyone's
probably
got
know
a
some
lawyer
folks.
on retainer.
Yeah.
Don't you?
I do. I'm talking. Actually, he's not my lawyer, Chris.
I am no one's lawyer.
He's no one's lawyer. So the lawyer looks at the situation and advises the parents to file a lawsuit to get to the bottom of it. Right? Like, we got to figure out all these unanswered questions about the school's not telling you anything. So, you know
They're
what?
not being very transparent. Like,
if you want
we need
answers,
to put pressure on them, let's do it.
Yeah.
Yeah.
Because that's, as soon as you file a lawsuit, then they have to answer questions. Right?
Yeah. You get to do discovery, and they have to give you the documents and all that stuff. And it's just a massive headache.
Yes. Document. Okay. So
they filed a lawsuit. Right. So on February 11th, 2010, the Robbins filed a lawsuit in federal court in the Eastern District of Pennsylvania against the Lower Merion School District, its board of directors, and the superintendent. Interestingly, they filed a lawsuit as a class action, ostensibly on behalf of all students who had been given district-issued laptops with the capability of the webcam being remotely activated and, who had also been subject to surveillance, right? So, that potentially, like, that's a huge class. The student body at this point is like 1,800 students.
Wow.
So, like, that's every kid who had a laptop. every family member of a friend, whatever it is. So like everyone who could have been captured both on the screen through like video chatting, massive class. And, you know, I think the strategy here is to basically just put more pressure on the district because you can do a deeper investigation. You've got more potential plaintiffs. Like, it's not just what happened to Blake. It's like, what was the district doing to everybody?
Right.
Yeah. So, like, it's an interesting strategy also to use the lawsuit as a mechanism to, like, get answers. There's a lot of different ways they could have gone about that, but I think the lawsuit is definitely the most direct.
Yeah.
Let's say.
So what's the complaint here? Like, how are they saying that the district broke the law?
Right. And so the gist of the complaint is that unbeknownst to these students and the other people involved in the situation, that the school district, without their authorization or consent, had been spying on their activities through the, quote, indiscriminate use of and ability to remotely activate the webcams incorporated in each laptop issued to the students. And so there's 7 counts or causes of action that are alleged here. So there's federal statutes, there's U.S. constitutional claims, there's state law claims, common law claims, all of the different things that we've talked about. The first 3 claims are all federal electronic privacy laws, and I'm just going to kind of gloss over that because, frankly, I don't know enough about that to talk intelligently about it.
Okay.
But the bottom line for those is that, you know, it's unlawful to improperly intercept communications without consent or a warrant. And so because the district was here collecting information about people using their laptops, how they were using their laptops, beyond kind of the scope of what, you know, they were doing with these computers, that was all, you know, bad stuff.
Yeah. So I guess another way to potentially look at that is, you know, had the district been forthcoming and asked everybody to sign consent forms and everything, those particular claims might not have had as much teeth. Right. The other ones maybe, but those particular claims that have to deal with you can't do this without consent.
Right.
Maybe. But doesn't matter. Anyway.
And interestingly, those federal claims and then like the state law equivalent claims from Pennsylvania include some pretty significant monetary damages. So like we're talking like big fines and things like that, and penalties, including one of the statutes, at least one of the statutes allows for punitive damages. So typically we talk about damages as like compensatory, trying to make the plaintiff whole to basically fix what the bad act caused. But punitive damages are a little bit different. They're the like, hey, that was really, really bad, and you and no one else should ever do it again. So we're going to make an example of you. Yeah. And so like, you know, punitive damages can be bad, can be real bad,
huge. Yeah.
Especially when you've got like egregious behavior, which may or may not be what's happening here.
Hey, look, it's good that this is a very, very wealthy school district.
Which is also probably part of the calculus, right? If you're looking at it from the attorney's perspective, like, oh, there's some deep pockets here.
Yeah. So, okay, so what about the other counts of Yeah, those other claims.
So the 2 really big ones that I want to talk about that are like the most significant for schools beyond kind of this general context, a couple of the counts deal with allegations of Fourth Amendment violations. So violating students' right to be free from unreasonable searches and seizures. So that's a federal constitutional claim. We've talked about that a lot on the show, but you know, whether or not a search is reasonable depends on the context. And in schools, there's different ways of kind of adjudicating whether or not a search is reasonable. If it's a search based on individualized suspicion, then you've got to satisfy TLO, which I think we covered in episode 15 maybe. And so generalized suspicion, that's searches based on individualized suspicion. The other standard is if it's just a general search of everybody, then, you know, it's just a balancing test and whether or not the school's interests outweigh the students' interests. So here it depends on like, did they turn on Blake's webcam because they suspected him particularly of wrongdoing? Then we're in TLO land and we have to prove TLO's 2 prongs, whether or not it was justified at its inception and whether or not the search was reasonably related in scope to the circumstances giving rise to the search. So like, you know, for the justified at inception, do we have articulable reasons for thinking that he broke a rule or broke the law? And then for the scope piece, like, is the search not overly intrusive given what it is you're looking for, what you're trying to accomplish, the level of intrusiveness into the protective property or protected privacy interest,
right?
And the age, sex, and maturity of the kiddo. So already things are not looking great for the district because you might have was his laptop stolen? Maybe that would justify a search. Technically, because this is everyone is agreeing that this is definitely an intrusion into a protected property interest, right? You definitely have a protected privacy interest in your bedroom.
Yeah.
Right. So, things are already not looking good for the school. So the last claim is a violation of privacy claim under Pennsylvania tort law. And so typically in order to make a claim for invasion of privacy, you have to show that another party intentionally intruded into a place or matter where you had a reasonable expectation of privacy. We just talked about bedroom, probably a reasonable expectation of privacy. Intentionally intruded is kind of an interesting thing because it's an intent standard. So we need to figure out did they take an affirmative action in order to intrude into his bedroom. And then the other piece of it is you have to prove that the intrusion would be considered highly offensive to the reasonable person. And all I'll say here is nothing here is looking good for the district.
No. Yep. Yeah. I got nothing, man. I got nothing to say.
Right.
This you is look one at every one of these check boxes, and district seems to be very clearly failing this test.
Right. The district doesn't have a lot of good arguments. Right.
Right.
I think this is one of those lawsuits where you get it and you're just crap.
Yeah.
Because the district's entire argument is basically our use of the software was pursuant to policy. We only used it when a laptop was lost and stolen. It wasn't, it was used only to identify where things were, and then it was turned off. It was only used in these very, very small circumstances. And then, whether or not that is actually what happened is,
we should have listened to that 17-year-old kid 2 years ago.
Right. Exactly.
Okay.
Immediately after filing the lawsuit, the family also files for a temporary restraining order, basically saying, hey, court, can you tell the district to stop doing this thing that is pretty, maybe clearly unlawful? This is all happening very, very quickly because remember, they filed this lawsuit before an investigation could happen.
Yeah. Because the district was not providing the family any answers.
Right. Yeah. So more information is coming out during the lawsuit, which is actually really interesting and not a wrinkle that we've dealt with.
Yeah. So it sounds like in this kind of community, things got out there real fast and got really, really loud. Right?
Yeah.
So apparently it was all over the news, within hours of this lawsuit being filed, right?
Yeah. No, this was international news.
Yeah. It's okay. So it spread so fast during one school day that the principal got on the loudspeaker at the end of the day to tell students that they were aware of the rumors that had been circulating and that they were false.
Good. Right. Yeah. So that principal had obviously never heard of the Streisand effect.
So listen, one part about this that I find fascinating is that the community fractured almost immediately. Okay. The Robbins family, they were heroes to some, but villains to others in the community.
Right. Yeah, because they're suing the schools. Everyone loves the schools.
Right. And after all, they gave my kid a $2,000 laptop.
Right. Yeah. And they're boosting up my property value.
Yeah. And the district eventually admitted publicly that, yes, the TheftTrack software did exist, but insisted it was only used for lost or stolen laptops. But it's important to note Blake Robbins' laptop had not been reported lost or stolen. So, I mean, it's, again, the school district, as beloved as they must be by some, or as they were by some, just really seems to be tripping over its own feet here. over and over and over
Right.
again.
Well, and I think that the big thing here is that there's not a lot of internal consistency with the district about like who knew what when, because like this just sounds like the IT people put this on computers and no one else really knew about it, or like
Director
at least
didn't
that's
even
the
know.
impression I got. But you know, the community fracturing I think is really interesting.
It is interesting.
Because like, you know, I think there was a perception here that like, oh, well, you know, this family is just filing this for the money, or it's not that big a deal. Like maybe if Blake's webcam was on, it was because he did something bad and like, you know, he kind of deserved it sort of rationale, right?
Yep.
So like, but this just highlights how hard these cases are, right? Like the people who bring these lawsuits suffer real consequences for bringing light to these injustices.
Yeah. So messy, right? Like, and part of the reason why the community fractured and everything, a lot of people thought that this was about money and not principle. The Robbins family maintained otherwise.
Of course.
You know, and so just real messy in the community and lots of people being affected. But then a court order forced the district to turn over the photographs that they had of Blake specifically. Okay?
Okay. The court's getting involved.
You ready? Over 400 images.
Okay.
Some of them
What
were
are we doing here?
Wait. Some of them were of him sleeping in his bed. Per the settlement documents, TheftTrack was activated on Blake's laptop from October 20th through November 4th, 2009. Just in the window of October 20th through October 28th, at least 210 webcam photographs and 218 screenshots were taken from his machine.
All right. Time out. Like if you're just doing a theft track, like you know he's got it, right? You could establish that with one picture. Why are you tracking it for 2 weeks? This is
the kid who we gave the laptop to, so it wasn't stolen.
Right. Yeah. Like we know where it is, guys. So going back to TLO and, you know, justified at its inception, you know, I think at that point, Blake had kept losing his laptop or something. And so this was a loaner and the school said like, hey, maybe don't take this away from campus, but he did anyway. So like maybe there was a justification there for like, hey, did that loaner like go home with Blake? Let's check. What about the second prong?
Picture.
Right. And yeah, the second prong is is it reasonably related in scope to the circumstances justifying the intrusion? So like, is it not overly intrusive? Monitoring him for 2 weeks with over 400 images is clearly over intrusive because not only is that too long to do what you're trying to do, it's too intrusive in how it affects his privacy interests, right? Like it's in his bedroom at home. That's one of the most private places that we can imagine.
Yeah.
Oh, this is one of the things where I just looking at it go like, what were you thinking?
It's, you know what? It's even worse because emails between the district officials indicated that it was known that Blake had the computer at home and that administration had advised them to leave the theft track activated over weeks.
Oh.
Like,
This is emails, right?
Emails.
You got to be careful.
Because they're going to be read in court.
Or on chalk and gavel, as the case might be. Okay, so there's clearly something on here where like someone has acknowledged that they've got this tool and they're like, oh, hey, I could use this.
Yeah.
There's something going on there.
So, you know.
Yeah, like all they had to do was call into the office and say, hey, do you have that laptop we gave you? Or, hey, give us that laptop back.
Yeah.
Like that's a one-day thing.
Yeah. What reason could they possibly have?
Right.
You know, and that's the big question. Some believe that the district had it out for Blake, right? Like, and this is revealing the fracture in the community, right? He's this troublemaker kid. They were just trying to find something that they could use against him.
Right.
You know, so the district releases Blake's photos to his parents, more than 400 images of one child in his bedroom, and Blake is one student.
Of 1,800,
right? So then the question obviously is, if they've got 400 on this kid, What about the 1,799 others?
Right, yeah. Because now
Right?
it's like, oh, Blake, whatever about them. But now it's like, oh, wait, that could be my kid.
Yeah. And then the full numbers broke. The district had commissioned an independent investigation into the issue. They hired a well-known law firm who assigned the case to a former federal. That's hard for me to say. A former federal prosecutor who lived in the district and whose child attended the school there.
Oh,
Right?
interesting. Okay.
Yeah. So the district hired the firm to go ahead and represent them in the matter.
Wait. The firm doing the independent investigation is also representing the school district in the litigation?
Yes. Can you say conflict of interest?
I can. Conflict of interest.
Well done.
That doesn't sound very independent.
Yeah. But do you want to know what the investigation turned up?
Yeah,
by
what did this independent totally
inv-
biased investigation in favor of the school district turn up?
So it revealed 179 activations of TheftTrack across both school years, 2,306 laptops issued, 36 laptops had images captured. The total, 30,564 webcam photographs and 27,428 screenshots.
Oh, my goodness.
In total, almost 60,000 images were taken.
Wow. And these were all just sitting on a server somewhere? Like,
Really?
I mean, number one, only 36 out of the over 2,000 laptops. Like, that's not a big number, but it's not a small number. But 58,000 images?
Yeah. So let's talk a little bit about how all the accusations that the district handed out for Blake.
Please.
So the court ordered the district to notify all of the parents of all of the students who had been impacted, and there seems to be a common thread amongst many of those who were impacted. Okay. They happen to be students who have had some run-ins with the office. Okay. So, for example, one student who later filed a lawsuit against Lower Merion as well had been in the office a few days prior to his webcam being activated. He had never been in trouble before, nor had he ever reported his laptop lost or stolen, but was questioned about a reported theft. Administrative officials found no evidence that this student was involved after a consensual search of his belongings. But according to the student, he began to notice his webcam being activated the following day.
So that tells a very interesting story.
It doesn't sound like it's limited to two IT people who are directing this.
Well,
right?
I imagine there's a trail of evidence here where someone is like, hey, by the way, can you turn that on for so-and-so's laptop? And just somebody doing it.
Yeah.
Like if this is being used in a targeted way, and I think, in the complaint, at least, maybe not in the complaint, but in some of the reporting, there were also allegations that maybe this was also a racial thing where minority students were more likely to be targeted. There's a lot of, and none of this gets really further developed in either the independent report or the lawsuit. But, there's definitely some deep questions here about what were you doing with this technology? And it clearly wasn't just to identify where a laptop was and whether or not it had been stolen or lost. So yeah, serious questions about whether or not this software is being used for legitimate purposes or if it's being used to spy, for a lack of a better word, on students to find evidence of, improper behavior.
And that's the thing that the Fourth Amendment is designed to protect against, right?
Yeah. Hey, government, stay out of my business.
Yeah, so government jumps in. The FBI opens an investigation.
Now we're getting serious.
Yeah, calling out the big guns, so to speak. The FBI opens an investigation on potential federal wiretapping questions as well that runs concurrently with the civil suit.
So now you've got a lawsuit and a criminal investigation.
Yeah, this ain't looking good.
No.
So this popular opinion fracturing of the community, right? Now it's starting to swing back in a different directions. Parents who had signed the petition against the lawsuit were now asking, oh, what could have happened on my kid's laptop?
Right.
Right? The report also noted significant problems in the IT department. There's lack of an official policy, lack of oversight. Neither the board, the district level administrators, school level administrators, not even the IT department leaders had imposed any official restrictions on the use of the TheftTrack feature. So it sounds like anybody and everybody.
Right. It's the Wild West. Just tell me when to turn it on.
Yeah, exactly. And the report also confirmed what the whistleblower email told us 2 years before, that the people running this program knew what they were doing and they kept it quiet.
Right. So there was a student who saw it all coming.
Yeah. But don't worry about it, kid. Just take a breath and relax.
Oh, man. Yeah, maybe take more than 7 minutes to answer that email.
Yeah. Maybe recognize we got a little bit of a problem here.
Right, yeah.
That we got to work on.
Yeah. So, for all the reasons that Jamie and I have talked about, there was a lot of issues with this lawsuit, or with the district trying to defend this lawsuit. And so, the district obviously leaned hard on their anti-theft justification, like they had a legitimate purpose. They claimed they had these protocols. It was only activated if stuff had been lost or stolen. Not maybe the strongest argument given the evidence that is coming out. And, that might be why the parties pretty much immediately settled this case. And so the court starts entering this series of orders in February, March, April, and May of 2010 that continue to kind of restrain the district's use of their software and requiring like preservation of the images. They're requiring them to like, hey, you need to show students the images you have of them, like lots of orders like that. And then the court enters a permanent injunction in October of 2010, which says, hey, stop this forever.
Yeah. Permanent, not a temporary injunction.
Right.
Nice.
And it's a pretty comprehensive injunction. So it tells the district to stop and never, ever, ever use it again. Stop your remote activation of webcams. Stop the screen capture stuff. Like all of that needs to stop. You can still do anti-theft tracking stuff, but it has to be in ways that don't infringe on their privacy. So like maybe a location tracker or a GPS or something like that.
And you have to tell people about it.
Right. And there was a requirement that you had to have like, hey, maybe you should tell people what capabilities you have in relation to this stuff. The settlement also requires the district to create more policies and more clear policies around the use and monitoring of student devices, not only for like student reasonable use and like you said, the consent piece, but also for like what the district is going to do and the policies and procedures they're going to follow for all of this stuff.
Yeah. So basically the injunction is like, okay, you stop using the webcams, fix your policies, tell people about all this stuff, make this right.
Right.
Right. So what about the money?
Right. And that was a big part of the public conversation about this lawsuit, right? And so the family was seeking compensation for the invasion of privacy and all the other stuff that had been going on.
Right.
And the district agreed to pay $175,000 to Blake Robbins as full satisfaction of all the claims. So here's what we're offering. You drop the lawsuit, we'll give you $175K. Of that, $150 was to be placed in trust for him until he turned 18, and $25,000 was placed in a money market savings account for his education, health, maintenance, and support, and specifically for purchasing and insuring an automobile for Blake Robbins.
What?
In the settlement, it's money set aside for Blake to buy a car.
Why?
Because he's a 15-year-old kid.
But what does this have to do with why? Well, like,
that's just what's in the settlement.
Okay.
Yeah. So interestingly, the defendants, the school district, also agreed to pay the Robbins family's legal fees and costs. Remember, because
Okay.
this is a constitutional claim. There's fee shifting. So, like, they could be on the hook for the Robbins family's attorney.
Right.
And so they agreed to pay the Robbins attorney the amount of $425,000.
Oh.
Yeah. So the firm claimed that their actual fees and costs exceeded $500,000. But they voluntarily reduced that down to $425,000 to settle the matter.
Okay. That's interesting. So what happened with the FBI investigation?
They dropped it. No criminal charges were filed.
No harm, no foul?
Well, I don't know if that's what they said. It was more no harm or no foul, no criminal intent. Kind of decision. So I don't know if they were saying there was no harm. There was just concerns about whether or not that the school officials had the criminal intent required for prosecution.
I don't know how I feel. I mean, like, maybe they didn't have criminal intent, but like, if you don't have criminal intent and you did all that stuff, you have a lot of something else, which
Negligence,
is poor
right?
judgment.
Oh,
like,
also that.
Like, and not just poor, like incredibly poor judgment.
Right.
Because you were also warned by a kid.
Right. Yeah. Yeah.
Like-
and that was kind of what the report, the independent investigation report, kind of hung its hat on. Its ultimate finding was that there was no intentional spying on students. And, the words intentional and spying, I think, are doing a lot of work because some lawyer had to define those words in very specific ways to get around what it is that they were doing.
Oh, man. So interestingly, back to that, what he was holding up in front of the camera.
Right. Yeah. We've come a long way since then.
Yes.
$600,000 long way since then.
The AP thought it was drugs. The kid, Blake, said it was a Mike and Ike's candy.
So all of this was based on a Mike and Ike's candy that he's holding up to his webcam.
Yep. A federal
my
lawsuit,
gosh.
$600,000 settlement, FBI investigation, 4-part Amazon documentary, and a kid holding a Mike and Ike. Yeah.
Well, there's a takeaway for you right there.
Yeah, that's right.
Don't make mountains out of molehills.
Don't eat Mike and Ike's.
I like Mike and Ike's.
No, Mike and Ike's are fun. They're
Yeah.
good. All right. I mean, like, listen, if you don't know what the takeaways are,
Right. This one's pretty
At this point.
straightforward.
I would suggest listening to this one again.
Yeah. Have policies. Know your policies. Follow your policies. Know the law, because somebody somewhere should have raised a concern about, like, hey, is this illegal? Should we?
Somebody
be doing this?
did. Somebody did.
Well, someone in a position of authority should have listened or
Yes.
raised the same concerns.
There you have it, folks. That's WebcamGate, Robbins versus Lower Merion School District. What's the homework?
Your homework is to eat your Mike and Ike's in private.
Keep them off camera. Like,
need
rate,
to-
review,
Yeah.
social media, website, chalkandgavel.com, buy merch, do all that fun stuff, and then join us back here again in 2 weeks, as you already know. All right, everybody. We'll see you soon. Have a good one.